Bismillahirrahmanirrahim. Today I'm going to deliver lecture number 3 on companies law. So dear fellows, this lecture number 3 comprises of 3 topics mainly, in which we discuss section number 29, 30 and 31, and we go into all the wiries of these sections. Section 29 is about memorandum of unlimited company, section 30 is about borrowing, and 31 narrates the information as to the structure of the memorandum. So we come towards section 29 without wasting time in order to get clarification in all 4 corners. This section is very important in its own for those persons tend to make an unlimited company. So as this word describes the authenticity, the genuineness and all the wiries with which it relates. So firstly, I discuss the general law over unlimited companies, that how the unlimited company can be formed and to what extent the liability of the members of unlimited company is constituted. So the unlimited company, which is also known as ULL commonly, or a private unlimited company, is a hybrid company corporation which is incorporated with or without a share capital. So the option is available for those persons tend to make an unlimited company, that either to select the share capital or to ignore it. So this option is available, but on the other side it also creates the legal liability of the members whether they select the share capital amount or not, irrespective of this fact. So the general law provides about it that where the legal liability of the member or shareholder is not limited. So where the legal liability of the member or shareholder is not limited, then we give the name of unlimited company to such structure. So in such case, the members or shareholders having a joint, several or non-limited obligation to meet any insufficiency in the assets of the company, to enable settlement of any outstanding financial liability. So what are the dimensions provided under this scheme of law regarding the ascertainment of the liability of the members? So the law provides that unlimited company constitutes the journal, several and non-limited obligation. So this is the hierarchy under which the unlimited company works. Moreover, it is done for eradicating the effect of financial liabilities in the event of the company's formal liquidation. So once the company is going to liquidate formally through a proper channel, then this mechanism need to be followed. So one more very significant thing is discussed under general law, which attracts the attention of the persons tend to make the unlimited company, which is regarding accounts. ULLs do not have to file public accounts and thus offer greater secrecy. So this is the place which really attracts the attention of the persons, that ULLs is not required to file the public accounts. So this provides security to the business community. Now we come to the characteristics, that what are the dimensions, parameters and the regions where this company need to work, and why the preference is given to such unlimited company. An unlimited company has the benefit and status of incorporation. So obviously this company having some benefits and also having status of incorporation, therefore it provides different dimensions to the business class. and these dimensions are same as limited company counterpart. So the situations for which an unlimited company will be preferred to an alternative business model or its limited company counterpart include these. So what are those factors on which a reliance can be placed in order to initiate any business activity under the head unlimited company? So the first clause provides that secrecy concerning financial affairs is desired, effectively shielding and protecting its financial affairs from public, media, and competitor analysis. So it provides that you can save the skin of the company in terms of financial affairs from public, media, and competitor analysis. So these are the three places which come forward and try to intervene into your company's account, and this thing making them non-public information. But it includes the shareholder dividend payments. So this clause 1 provides that we are not required as unlimited company to disclose the financial affairs of the company. So the clause 2 provides that the company is active or trading in an area where limited liability is not acceptable. So the hierarchy, parameters, and the ambit of the company is defined for its working style. So unlimited company can only be constituted, can only be framed in those areas where the limited liability of the members of the company is not acceptable. So it clearly envisages, clearly elaborates that two parameters are defined: limited liability and unlimited liability. Unlimited liability can only be framed where no scope, where no place is given to the limited liability company. Then clause 3, which elaborates that extending in journal a greater assurance and confidence to creditors and trade financial transactions, in contrast to its limited company counterpart. So it provides greater assurance and confidence to the shareholders and to the members of the company. Further, it is a very low risk of insolvency. Where your unlimited company is framed, then the level of risk always diminishes, always decreased. So the next clause provides that the company or its trading activities has or generates sufficient capital, funds, or financing without need to approach journal lenders such as high street retail banking. So this is the company which generates in its own sufficient capitals, funds, or financing without approaching the journal lenders. So this is the point of distinction which clearly take the unlimited company one step higher than the limited companies. Next, it provides that a focused high standard of board of director and executive management behavior and business model for risk management. So this is the model framed in order to create a line of defense against the risk, and provides a baseline which creates a very solid defense in case of difficult situations. And further, it elaborates a flow through entity is required for tax purposes. So it is also considered as a flow through entity, and it is not incorrect to say that it is the ideal scheme for the business community. And now we move towards that once the unlimited company is framed, then whether the option is available for its conversion or not. So the journal law provides in this regard that once formed or incorporated, an unlimited company can in some jurisdiction also re-register or designate itself to limited company status. So the unlimited company can be altered into the limited, and limited can also be altered into unlimited. So vice versa option is available under this scheme of law. Now we are going to the context as stated under section 29 of Companies Act 2017, and we discuss all the parameters as defined in detail. So the section 29 of Companies Act 2017 provides that in the case of an unlimited company, the memorandum shall state. So what the memorandum of an unlimited company state, as we have discussed in memorandum of company limited by shares and memorandum of company limited by guarantee. So lecture number 1 and 2 we have discussed section number 27 and 28. Now we move towards the content of 29. Likewise, 28 and 29 clause A provides that the name of the company with the word unlimited as last words of its name. So the unlimited word need to be used as the last word of the proposed name of the prescribed name. So this is the thing which identifies and creates a line of bifurcation. Now clause B provides that the province or the part of Pakistan not forming a part of province, as the case may be, in which registered office of the company is to be situated. So the clause B of section 29 provides that province need to be determined where the business activity need to be held. So the province is defined and the name of the company is defined under clause A and clause B of section 29. Now we move towards very important clause C, principal line of business. So this is the place which identifies, classifies the dimension of the business with which under which they need to work. So the clause 1 provides the object clause. The existing companies shall continue with their existing memorandum of association, and the object stated at serial number 1 of the object clause shall be treated as principal line of business. So principal line of business is a baseline, and it is a very substantial line in the eye of law, because nobody can move away from the principal line of business. And where it is stated under the object clause of the memorandum of association. So the clause 2 provides that specific intimation is required to be given where object is not defined. So in some of the cases the object of the company is not expressly defined under the memorandum of association. So under those cases a specific intimation is required to be given to the concerned registrar regarding the principal line of business. And in case of abstinence from this procedure, it may take the company towards striking off. So the clause 3 of section 29 envisages the parameter of working. And how this parameter can be ascertained, the context provide the existing companies or the companies to be formed to carry on or engage in any business which is subject to a license or registration, permission or approval shall mention the businesses as required under the respective law. So not only the company's incorporation is sufficient for holding the business activity. There are some ancillary, there are some incidental things need to be done which are directly and indirectly linked with the principal line of the business. In some of the business activity licensing is not required at all, but in some of them without license we can't even move one step forward. So the clause C gives a hardline direction to the company's management that licensing is required with respect to the regulatory laws. So the clause D provides an undertaking as may be specified. As we have discussed under section 28 and 27, that undertaking as may be specified. So the undertaking from the management of the company is necessarily required in order to hold any business activity, without which no activity can be commenced. Further, clause E provides that the liability of the members is unlimited. So the word unlimited is used as the last words of the proposed name, and this is the way how the liability of the member is construed. So subsection 2 provides that share capital to be determined at the time of the commencement, at the time of the incorporation of the company. So as we had discussed under section 27, 28, so the section 29, which covers the dimensions of the memorandum, also provides that the share capital need to be ascertained and need to be allotted to the members of the company with respect to their interest. So this discussion covers all dimensions regarding the memorandum of company, which constitutes the unlimited liability. So now we move towards section 30, borrowing powers to be part of memorandum. So what are the borrowing powers and what are its essentials, what are its credentials? So the general law provides over this topic that every trading company has an implied power to borrow. So this is not just expressive power, it is just an implied power to borrow, as borrowing is implied in the object for which it is incorporated. So the borrowing is the factor which is expressly envisages in the object of the company. So now we bifurcate the trading company and the non-trading company. A trading company can exercise this power even if it is not included in the memorandum. Even the borrowing factor is not included in the memorandum, still the trading company having a power to borrow without any expressive directions. However, non-trading company has no implied power to borrow. Once again I repeated that, however, non-trading company has no implied power to borrow, and such power can be taken by it, implied power to borrow, and such power can be taken by it by including a clause to that effect in the memorandum. So the non-trading company can only borrow where the term borrow is expressly used under the content of the memorandum. So the further classification of borrowing is provided, and in case if the lender comes into action, then what are its dimensions. However, if the lender has acted in the good faith, that is without any knowledge that the company borrowed the money beyond its power, he may have the following remedies. So in those cases where the borrowing is done without jurisdiction, without its limitation, then what powers are available? So we generally classify this thing into 5 categories. One is injunction, restitution, subrogation, suit for breach of warranty, and ratification of borrowing. So firstly we move towards injunction. If the company has not spent the money so borrowed, the lender may obtain an injunction order against the company restraining it from spending the amount and recover the same. So in those cases where the borrowing is done without jurisdiction, so the lender can take back the money in those cases where it is not spent.